Welcome to Bad Law, Worst Facts. My name is Michael Takla. Today I have two great guests on. They just got a $479,000 verdict against Allstate in a UMUIM case. Let's introduce yourselves.
Hey, this is Edward Festeryga at Abraham Watkins.
Nancy Flores with Abraham Watkins.
All right, y'all got to tell me about this case, because from what I've understood, there are a lot of bad facts and not very much hope, but you guys decided to try it anyway.
Yeah, if this case had problems, I mean, this is like a simple-faced 15-year-old in high school. It had all kinds of problems all over it. But what we did have, to give ourselves some credit, is we had two really good people, small business owners, and we had some witnesses, their wives, who were excellent. But to get into the bad facts, yeah, we had neck injuries and we took recommendations, but we had guys with neck problems, popping 7 out of 10, complaints getting all the way back to the 90s, and treatment for neck conditions with 7 out of 10, reported pain up until like 2 weeks before the wreck. And then after the fact, we had a couple guys who were playing racquetball and playing basketball and doing their best to live their lives, but certainly nothing that was documented in a way to suggest that they had severe injuries necessarily that would require real care or anything into the future. So it was hard to kind of get over that. And then on top of that, I mean, part of their presentation, I think somebody texted me that it looked like I was representing Uncle Rico during the trial. So look, I mean, we had some obstacles and we had some challenges, definitely in the record and in terms of the presentation. But when you have good people and good witnesses, and then great lawyers like me.
So what was the pre-lit off?
We had 2,000, so we had two plaintiffs. We had 2,000 for one guy, and I want to say it was like 9 or 10,000.
Okay, even worse. All right. So you got $2,000 offer and $10,000 offer, and you're like, okay, we're just gonna try this case.
Well, let's say that this case was, I don't want to say it was sitting around, but like everything else, it got jammed up and never had an opportunity to try. So that case was sitting there for 6 years. This was a 15 filing?
Right, yeah, it was a 15 filing, and it was one of those cases that there's no other option to file. So
we should also add that our guys hadn't treated it.
They hadn't treated it.
Okay, and they had a surgical wreck?
They had both of them had a surgical wreck.
Okay.
With like prior surgeries for the one guy, complaints, up and down the board. He had a prior surgery to his lower back.
Okay. So I'm going to give a second for my viewers, because I'm pretty sure they just opened up a notepad and said, okay, how the hell did this happen then? Right? How did we get a verdict like this on these type of facts? Right? So, put me in that room. What was y'all? I'm sure you guys got together and decided a theme and try to go from there. So what was the thought? What do you want to present to the jury?
Well, I think Nancy, and kind of fill in if you want, but I think first of all, we need to orient and say, look, this wasn't a straight car wreck case, right? This was something different. This was a UMUIM case, which to the listeners in Texas has a little bit of a different deal, and that gave us an opportunity to try a little different tack.
Right, yeah. So we wanted, the nice thing about this case, or I guess, I don't know if I want to look at that, but, we're going up against an insurance company, right? So the whole theme of our case is, policyholders are entitled to the policy benefit at the end of the day. And that fits well with the jury, that resonates with the jury. So it was a different kind of case than your typical car wreck cases.
Yeah, I think as far as what we thought about, we took a look at the case and went, look, we got some serious issues on there. Who was the villain in your case, which is often a question for employers. It was pretty obvious. The villain here was the insurance company, where they denied benefits to these guys who paid for the policy for 6 years when they needed help. That's easy enough. How do you sort of overcome or paint in the right picture what these guys were dealing with and why it was still appropriate for these jurors to try and give them an opportunity to get better? And the fact that they needed to get better was the real challenge. I will say this out the gate: the theme was easy. We took a look at the Allstate policy, and I think I've given you the opening statement and some other documents you can look at and pull up. But as you're coming through these policies, you'll notice at the very bottom, it says this policy is subject to a final audit. Well, I'm like, guys are sitting there for 6 years, and all we're here to talk about is, are they hurt? And if so, what's an appropriate number to help them get better? But it's just subject to an audit. So if what we're here for is the Allstate audit, maybe that's my thing. And so I kind of stumbled across, hey, look, this case is going to be the Allstate audit, man. You 12 people in Harris County, you're not here to decide anything other than how hurt are these guys? And Allstate says it's your job, not theirs. Even though these guys paid all this money and spent all this time over loyal customers going back to the 90s, it's up to you 12 folks to make a right and decide, do the Allstate audit for Allstate.
So, during Bordeaux, are you trying to create like a kind of us versus them principle, us being the jury versus Allstate? Is that what you're trying to push into?
I mean, that was I don't know, like that's definitely the focus that I went for, Nancy. Nancy kind of did her own thing. So we split up Bordeaux. It was great to have Nancy because she kind of cuts against a lot of the way that I am and kind of mellows out some of my stuff.
Yeah, not as loud.
Not as loud. So it was good to have her there. So we kind of split our Bordeaux in two different ways. We had sort of an inclusive component where it was like, hey, who here knows what an insurance company is and what they do and who Allstate is, and tell us about your experiences. So, I mean, for the young lawyers out there trying UIM cases, the benefits you have under the new case law, Allstate versus Irwin and deck actions, and that recent precedent that kind of opens the door is you can say, look, this is a case against an insurance company. These are the facts, and then you can start to develop some rapport with the jurors on those facts and on those concepts. Insurance company. How many of y'all had a problem with insurance company? We had a very active panel, thankfully, which we engaged right away. Like, I feel like one of the good things that we did was engage very quickly. For people that were a little bit reticent to talk, we kind of started up with them, developed a rapport, and then we're able to bounce that off to some other people. And then with some talkative people, it really just started flowing from there. So we had 2 or 3 people that were actively engaged with Allstate.
Right, yeah,
Really?
and we try to play into that, right? Because we have certain people in the jury saying, yeah, I have experience with Allstate. Well, tell me about that. What has your experience with Allstate been? And usually it's going to be a negative one, right?
It's hot garbage. Yeah.
Right, yeah. So we want them to kind of teach the other jurors who have not had the same or similar experiences, and to hear from them, right? Just to see like, hey, this isn't just about our clients. It's affecting everyone. It's affecting all of y'all.
Right.
So, picking at those jurors who have had experiences and letting them tell their story, that's the tactic I used, at least, is to kind of help educate. So we definitely played into that.
So even if they get cut off, right?
Right.
Who cares?
Yeah, they've already given you a lot of information that's going to help the other jury, right?
And if juror 37, so here's a couple things to think about. If juror 37 is talking about Allstate, well, first of all, he's not going to make the panel. It's just not going to happen. But if you're doing an inclusive voir dire, meaning you're not out there trying to get strikes with cause, saying, "Oh, well, that you can't be a fair minded juror in this case isn't right for you," no matter what anybody says, you're always going to hold that opinion. You're just listening,
right?
And it's great. And so, yeah, it doesn't matter. And even if they strike them, I'm not trying to hide anybody. I'm trying to make sure that everybody understands what the relationships are here and what this insurance company is and how it makes money.
Yeah.
And so long as people are on board with that concept, and we have 2 guys who were great guys and small business owners. Actually, I thought about this, but I opened by saying, these guys are apologizing to me. That was my first line.
What do you mean by that?
So I said, my clients don't know why they're here. They thought they paid money for an insurance policy. This case is about them trying to get their insurance policy, and they walked in today apologizing. And I'm not happy about that, but I'm going to tell you that.
Jesus. Okay.
That's how I started it. So I put them in there being like, hey, look, these guys are, and which was true. Like, they walked in, and the first thing I said was, first of all, I love y'all because they're my clients, and I believe them, and I love them, and I trust them. And they're phenomenal guys and good people. They're like, hey, man, like, I don't know why we're all here. I don't know why these people are here. We can't figure it out. We thought we paid money for this policy to help. I said, all right, man. Well, first of all, I love y'all, and let's go get it. And then that was the first thing that we did in Board I was just like, hey, look, my client came here to apologize. And that eats me up.
So how many witnesses in this case?
We had 5 total. So we had both plaintiffs. We had the spouse of both plaintiffs, both really nice ladies. I thought that the wife of one of the guys was phenomenal, and she had a great story and put a lot of texture into the case through her story. And then we put on a doctor by it.
Give me the open. You gave me a little sneak peek, but you got to give me an opening.
Well, I think the beauty of it is the opening played right out of the way that we did Dyer, right? So we set up with Dyer to say, this is an insurance company, and you know what an insurance company does, and all this stuff. The opening goes, hey, look, these are 2 small business owners who are involved in this terrific guys. Okay? And I walk them through the action piece by piece. They got an insurance policy with this insurance company that they've been with since the middle of the 90s to be there when they.
What was their policy?
It was, you mean like how much was it?
Yeah.
$500.
It was a 500 policy.
Yeah.
So it's not like it's a 30-60 I'm paying, pennies a month. Like he spent money to make sure.
It was a commercial policy.
Yeah.
So like this guy is a small business owner.
Right.
Small business owner who had ran a business. He had a pool business, which, mind you, pool business, not exactly labor intensive, right? These guys dig and clean pools, and they've been doing that for the last 6 years.
Yeah.
And I'm literally out there. I'm like, look, these guys are out there struggling, digging pools.
Yeah.
Cleaning pools.
Yeah.
But that's what we do in America. We continue, we go on, we do what's right, and we hold ourselves accountable.
This wasn't a worry for you guys.
I mean, that was a worry.
Yeah,
what are you
but I
talking
mean,
about?
because I mean, you sold me right there, right? But I'll be honest with you. I'm sure there's cases on my docket right now that I'm looking at. And I'm like, this guy's a baseball player. He's having shoulder injuries. Like, come on, was this on this collision, right?
Yeah.
And you guys sold it as, look, life goes on. You got to keep going. He's not going to stop doing this.
There's a really good.
I was just going to say real quick. I mean, those are things that you need to get in front of, right? Because if you don't present it, opposing counsel is going to present it,
right? And
the jury is going to wonder why you didn't talk about it, right? So you want to get in front of it. You want to talk about it. You want to paint a picture for them. And in this instance, it's like they're hardworking men. They have a job to do. They have mouths to feed. They have a family. And that was our whole. I know Teddy played into that a lot. Opening.
The truth needs no defense, man. It needs a messenger. Your job is to go up there and tell the authentic version of your client's story. You're not there to apologize for them. And typically our approach with our clients, look, we work at Abraham Watkins. We have these massive cases. I've got death cases, burn cases, quadriplegic cases. But in those cases, it seem be easier to tell in the sense that you have these horrible injuries. But our clients and these two guys that we represent in this case, they were winners. As in, they didn't sit, they didn't mope, they didn't cry. They got out there and they said, hey, look, I have mouths to feed. This guy employed like 6 or 7 guys. That was a huge part of our opening. What was this guy going to do? Go, oh, my neck hurts, I'm going to stop?
Right.
No, he's going to go, hey, look, I have a job to do. I have a family to support. I have men who rely on me, men and women who rely on me. And so we leaned into that and said, what else would you want? What else could you want from 2 people involved in it? And the nicest thing about the case is we had a big hit. Even if it was the second collision, this person ran it. It was an intersectional collision. Probably should get that out there. Intersectional collision. I don't know Houston, honestly, well enough, but like 59 and 610, kind of by the Galleria-ish area. Not off the highway, it's on one of the feeder roads. But the defendant driver, like the third-party driver, hit somebody else first and then hit our car. But the PD was pretty good.
Yeah. It wasn't a low impact.
No,
not very visible property damage.
The PD was available. The PD was there to see it. We got that in, and there was no issue on getting.
I think you had a lot of other issues, right?
Right.
Okay, so thankfully that was not one of them. Okay.
But we were able to come in there and go, look, nobody's faking it.
Right.
Right. And then, and not only that, they're not faking it, but these guys have continued to triumph and persevere. And all we're looking for is for someone to say, yes, we understand what you're dealing with, and we want to help you get better and give you a chance.
Right.
That was it.
Okay. So walk me through the opening, and then after that, I want to talk about what's the defense here then, right? You guys have sold me on it, so I need to know, what was Allstate saying, but walk me through that opening first.
The opening goes like this. I mean, the first thing I'm doing is introducing the guy. So I go like, hey, I'm here representing John Smith. I want to tell you a little bit about John Smith. John Smith, a good, hardworking man. He started his own pool company in the 90s. John Smith's married to a wonderful woman, 15 years. At the time of this accident, they were going to move on and move into the 14 years. They love to fish, they love to hunt. They had a son as a football player. And I want to talk to you about Mr. Joe Taylor. Joe Taylor, hardworking man, recently married. Accident, I'll tell you, his mom passed away. That's going to come into play. We're going to hear about that. And these guys were everything that you want and everything you could hope for from people here in Texas. They started a small business. They're hardworking and never stopped. Well, let me show you what happened. And I think probably before that, I said I included something about them, paying for an insurance policy and all that kind of going into it. And then definitely, if you run through the slides and do it, I say pretty clearly on that we're here for the Allstate audit. That's a huge part of it. So I also say, Mr. Joe Smith was a longtime customer, standing as a customer of Allstate. They bought this policy, and they bought this policy for just this type of occasion. When they needed it most, it was going to be to support them and help them through whatever they That's why they bought it. He bought it for himself, and he also bought it for his friend, coworker, make sure that he was okay with something. And then when they needed it most, Allstate says, "We don't have to pay you anything. We don't have to do a single thing. You have no obligation until 12 people in Harris County tell us that you have to. Get no benefits until someone says, so you're interested in getting it. Here's how much." And so 12 people, you know what you're here for? You're not here to decide, is anybody at fault? You're not here to decide anything like that. All you're here to do is Allstate. You're here to perform the Allstate. And then I launched into the crash, and I went through a few more things, and I went through the treatment records, and we're pretty engaging.
So did you get out in front of the pre-existing conditions?
Yeah, I'm sure I did. I don't recall off the top of my head. I would have got into it. I think I definitely said, look, these guys are not daisies. They're not spring daisies, not spring chickens. I would have said something to that effect. And I would have said, look, these are, and you'll see if you pull up the slides on the opening, but I do include their ages right away to say, hey, look, this is a 54-year-old and a 48-year-old man with 54-year-old and 48-year-old backs. These are not people who were born yesterday or 20-year-olds who were spring and spry. These are guys who worked, who had lived, who had been upstanding and producing citizens of our community. And yeah, they're not perfect. And also, a huge part of our desire, to go back to it, but a huge part of our desire was we take people as we find them. And then I gave two stories about my sixth grade teacher, Belinda.
My sixth grade teacher,
Belinda.
All right. Tell me about this one.
Well, I said, look, y'all, I got this sixth grade teacher, Belinda. I said, first of all, she makes terrible cookies. I told her that to her face. And they said, well, that's not very nice. I'm like, yeah, but what we need to do is I saved everybody else from this shit. And so I got a couple laughs. But that was my brutal honesty, though.
Yeah.
So I thought, hey, what I need from you, I don't want anybody here eating bad ass cookies. So I need to know, does this work for you? Just like I told my sixth grade teacher, Belinda, when I was walking through the neighborhood. I'll tell you something else about her. Belinda, I remember one time she was walking to the grocery store. She pushed her cart, and so we got his kids with her. She runs his cart right into her. She's all done. She's still hurt, but she's getting back. It's okay, but she's still hurt. Didn't you know it? 4 or 5 weeks later, she still got this problem. Same guy, Chucky Taylor, pushing his cart around, hits her again. Now, with Miss Belinda, are you going to say, are you here and going to tell me that Mr. Chuck Taylor shouldn't be accountable for what he made worse? Or are you going to say, no, just because she'd already had that injury before, no, it is what it is. We're going to discount that, not even worry about it. On that. The point of the Belinda story is just to say this. We don't discount anybody for having a pre-existing condition if it gets worse. And if people already have a condition and you do make it worse, you need to make sure that you pay for whatever you do cause. We don't deny people the help just because they have something. So that I told two different ones. One was an exacerbation of a pre-existing condition, and one was something else, because there's a bit of a split, an aggravation versus doing something else.
Okay.
Can't remember. You can pull it up and see the notes and maybe feel free to share it.
Yeah, absolutely. Let's talk a little bit about the premium. I really like that idea. I really do. The idea that you're really honing in about. So let me go through this. So this is obviously when you talk about the full service, right?
Yep.
So you take his business card and you're like, this is the guy.
Literally, I'm like, hey, I actually grabbed his business card like the night before. I'm like, hey, man, give me the business card.
You just slap it on.
I just slap it in there, and then I gave the slide to the defense counsel, no objection. I'm like, yeah.
All right. And then this is where you start talking about the insurance policy?
Yeah. So right after we get into the introduction and we start talking about who the guys are, then you want to get into, hey, why are we here? We're here because they're here to get the policy benefits, right? There's a lot of policy because we do this.
Okay.
And so, yeah, they pay premiums all this time, dating all the way back to the 90s. There's their coverages. They're entitled to it. They get it. And then the very next slide is going to be a big deal.
And this is where you drop the hammer, huh?
Well, so then I'm like, so yeah, what's the final audit? I wonder what that means. It's because and then the next one goes, these people aren't here. They don't have to do a single thing until they get a judgment. So what are you here for? And there's a slide on it.
Okay, and then you go into the collision and everything like that.
Exactly. And we did these slides ourselves, of course. That's the first vehicle. Our guys were in the van there. For those of you on the podcast world that aren't seeing the visual, we had some pretty good PD, property damage, and relatively substantial on the second hit. And obviously, the damage damage to the defendant, the third party who was not part of our UM case, was pretty good too.
Yeah, absolutely.
Now, I actually called them, was able to reach out, and I was going to try and get them and get them into the case last minute. Oh, it was horrific. The crash was horrible. They didn't want to do it, and they're outside of subpoena range.
Yeah, shocker. They don't want to go to a trial where they talk about what they did.
That wouldn't be fun. I said, y'all consider if I Zoom. I always turn over every rock, man. I just try every angle I can to see if there's something that's going to be beneficial to the telling of these people's stories.
Yeah, absolutely. Okay, so you've got these people riled up, right? What do you do when you talk about the treatment and opening?
The biggest thing with the treatment and opening is I think it's important to talk about the fact that these guys are older. And so because we laid in, to circle back to what we talked about, we don't discount people for having conditions and we care about aggravations of those conditions.
Right.
Linda, exactly.
Yeah.
And just like my fifth grade teacher, we talked about this. You can always refer back to it, but these guys have lived some life. They lived this really good long life, and they were looking forward to the golden years, the best years of their lives moving forward until this point. And then you start talking about the treatment. Well, what did they have? What's going on? So we say, you're not going to hear that these guys were perfect. You're not going to hear that these guys didn't have any problems. You're not going to hear that these guys didn't have treatment. But what you are going to hear, what you are going to see is they never got epidural steroid injections. They never had herniations that were so severe or injuries that were so severe they had to go get MRIs. They never had to do any of these things that they ended up doing after the accident. Why is that? They weren't hurt that bad. They didn't get hurt in this accident. The accident that aggravated or produced new conditions and new symptomologies that are the real issue. And that's what we do. And then as we go through it, we show them some images. And I do think it's very important to understand if you don't show it, it's just words. So in our opening, we're running through this PowerPoint and we're talking about cuts to MRI. We have MRI slips. I've got the images from the ESI that I included in there, so you can actually see the ESI with the needle and the dye. And what that allows is a visual connection so that these jurors can go, it's not just talk. This is the stuff that these guys did and went through. They jumped in an MRI machine. They got the MRI. Here's what you're looking at. Here's the ESI. And then, you really, anchors might not be the right word for that, but you have to tie everything to something substantive so people can go, yeah, I see it. That's it.
Yeah. So off air, you were talking, and I wish I would have got it on recording, but you looked at, this trial at least as putting on a show. I think that's what you said, talking about that.
Well, I think that one of the problems that a lot of lawyers, not just young lawyers, but older lawyers as well, more seasoned lawyers, think that your object is to lawyer. You're not. Once you're in trial, the object is to put on truthful telling in the most compelling fashion of whoever your client's life is and whatever the circumstances of the injury, the circumstances of the incident are. That is what you're doing. You're putting on a production. And what you are using is the rules of law and the rules of procedure and the rules of evidence. Law, I don't know what those are, but rules of evidence and the rules of procedure as the prism through which you tell that story. But you are the producer, director, and performer in the truthful telling of these people's stories. And that's not an uncommon thing. I think there's all kinds of podcasts and all kinds of people who talk about it. But it is absolutely the truth. You are there to be compelling and give a really truthful and really good narrative. And that includes knowing how to maneuver yourself around the courtroom, posturing, using visuals, using different medium. It is the production that is important, particularly to jurors in the 21st century where you live in an Instagram and YouTube world, and media is all the more important than what you do. So if you're not doing those things, and you're not thinking about those things, and if that's not a tactic, not just a tactic, but part of your telling, and you're not doing the job.
Yeah, I hear that a lot of attorneys are going to say that, at least I've heard that they say that, look, Netflix shows, they're like 20, 23 minutes, right? You need to have your deposition cuts to around that amount. You need to make everything around that amount because now our attention span is 20 to 23 minutes. Because what do we do when we get home? We watch Netflix or whatever it is. That's how we visualize things now or take in information.
Great point. So how are you taking your depos to make sure that you're getting them down to 20-minute clips? Thought about that? Or are you just taking your normal depos? well, shoot, I mean, then you're not building in part of the production. So look, just like a TV person or movie person would make sure they go get a location or plan through the shot by shot by shot what they're going to do, storyboard it out.
Right.
If you're not taking a deposition with a mind to how am I going to play this at trial, if I want to present it by video, then you're missing an opportunity.
Yeah.
Now, did we necessarily have that in this case? No, because it was a 2015 accident or 2016 filing, whatever it was, and sitting around.
It's a UIM case.
Right.
You know, they probably evaluated not as high as obviously you guys got, right? But I get it.
But the point is, you got to think about that. And if you're not thinking about trial and trial presentation from the jump, then you are doing a disservice to your case, because we've all got there when we go to trial and we go, this is not good. I don't want to show this. I don't like this.
Even small things, right?
Yeah.
Giving such opponent an exhibit. If he's looking at the exhibit, that's great. But you want the jury looking at the exhibit at the same time. How do you do that? He is, putting it up on, share screen, whatever it may be. So it's looking line by line, point out, right? Whatever it may be.
Exactly.
However you're doing it. Okay.
Exactly.
Yeah, that makes sense.
And mind you, unless there's a real objection to it, you could put up, picture in picture, and there's different things that you can do to make whatever's happening more compelling, so long as it adds, and is beneficial to the telling. So, as an example, recently I've been proposing some people in the NBA industry folks, and I've talked to them to make sure that I establish that I've got a curriculum vitae and even some video footage that is a concise summary of their history and what they do. So I get it into Rule 106 and I try to establish that foundation.
Yeah.
When I go to think about if I'm going to play something like that at trial, I'm going to try and play it with them, subject to any objection, or I'll play it at some point. But if I can have a compelling visual, just like in any ESPN special, that's literally how I envision it in my mind. When somebody's talking, it's going to be like ESPN with a running clip of their CV and some basketball highlights.
Yeah.
I think that makes for a much more engaging, compelling performance, because it is performative ultimately. What you're trying to do is persuade, and persuasion is a performative act.
Yeah.
Well, then that's real stuff.
Yeah. Good example. We're in the middle of a draft. I can't listen to the people talk about the person we're drafting, but I can see their highlight reels while they talk about it. I'm like, oh, okay, it's interesting. But
exactly.
No, definitely. I definitely agree with that. So witnesses, how did that go?
I wanted Nancy to take all of them, but she would let me.
Yeah, we split that up. So we presented our guys and wives. Their wives did a phenomenal job. We got them up there, and we wanted them to also get in front of their, past injuries and kind of talk about that and tell a story to a jury as to, what were their injuries before this accident and how has this accident affected them today, right, in their day-to-day lives. And I feel like the wives did a great job honing that in. They're the ones that go home to them. They see them today. So they did a good job of kind of detailing that and giving a story to the jury.
So Nancy did one guy, one of our plaintiffs, and I did the other guy. And I will tell you, the way it worked was we wanted to put the doctor on kind of initially to kind of get in front of it, and we had a whole plan, and then every bit of technology was it just failed. We went in and we set it up, and we got in there early, and I'm pretty technically savvy, and it's literally part of my personal branding and persona, which is to be technically savvy. So I wanted to set this up on an iPad and be able to connect to my iPad on the court system and be able to show things and draw things. Like basically Tony Stark out there. I was going to go in there and be like, I am hired.
Okay.
But it didn't work, man. And so
you ended up being Spider-Man.
I ended up being literally Spider-Man. I was like, hey, man, how do I find my way home?
I mean, yeah, granted, we went.
Thankfully, I had Mary Jane to save me over here.
We went on Friday, the day before, the week before trial, and we tested everything out, make sure everything was in working order as you should, right? Yeah. Our issue is that we didn't go to the courtroom where we presented our case. So there were some issues that were brought up day of, right? And it was a simple issue. It was like an aux port that wasn't connected. That was affecting our whole audio. So we're kind of scrambling, or we're trying to make,
make do with what we
have. Yeah. So all right, well, let's present our first witness. Forget what we had planned. Let's just go with.
Yeah. So we put on a damaged witness who was the wife of one of our plaintiffs, and then we started with sort of our key plaintiff, who was the driver of the vehicle and the help of small business. And what I'll tell you is that in the UIM dynamic, who you have, nobody except the witnesses for the most part, unless there's contested liability. No, but even then, I subpoenaed the adjuster to show up, and even under USAA, wherein you're allowed to actually depose these people on a very narrow range of topic. I think
Right.
it's USA indemnity or something like that, or something like that. I forget the case is now. I can pull it up. Because the judge, who's a phenomenal judge and very experienced, was like, "No, you can't." I'm like, "Judge, here's the site." I
Yeah.
pulled it up for her. Like, thanks. They're not coming. You're not talking to them. You're doing nothing. I mean, I literally said great. I literally said great. I'm like, great. That's exactly what I wanted. And so, but the benefit is it shortened our trial. But then how do I mean, am I going to go out there and be a nice, is it just all going to be nice and like, hey, clients, you're so great, blah, 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 all this stuff?
Yeah.
That didn't seem compelling to me.
Okay.
So I put my guy up and I crossed him.
Okay.
What? I just, like, Nancy, did I not cross my own client? I mean, I feel like, can you tell it, or do you want me to just like launch into it? No, give something.
Yeah.
So, if you're looking at the trial, it's live streamed, so a lot of people are looking at it. And a lot of people did say, like, hey, why are you coming at your own client?
Yeah.
Right? But that's Petty's tactics. But I think it works. I mean, because you're getting ahead
Well, what's
of it.
defense counsel going to do?
Theme. Yeah, exactly.
They have to come in and be a nice guy. Like, I'm so sorry, sir. Your lawyer hates you.
No, literally that.
Diminishing everything that they do have.
Like, look, okay, so here's the scenario. You got to set the table, though. But like, I got a 54-year-old, very strong, like strong jaw, short hair, still had his hair on him. I thought I read a note that he smoked like 10 packs a day, but he was like a pack a day guy. Like, he was a rough and tumble good Texan dude. So I'm like, okay, man. But he also was getting chiropractic treatment on his neck, the exact same part of his body, complaining the exact same symptoms 2 weeks before this wreck.
Yeah.
Talking 7 out of 10 problems with my neck, shooting down into my arms.
Right.
Like, stuff. Like, what am I going to do?
You were like, I'm going to confront the hell out of
literally was like, are you lying to us, Brad? I was like, what is going on here? You're getting treatment up until 2 weeks before this wreck. Explain that to these people. That doesn't make any sense.
What's the response?
He was like, man, it wasn't the same thing. It was different. I was like, I tell you, like, yeah, I went to the chiropractor for sure. I mean, this is what it was, but it was never this.
Yeah.
It was never this. It was never every night. It was never something different. And so I'm like, Brad, well, crap, man. Tell me more. I've thought enough. Tell me severity. Tell me frequency. Tell me duration. Tell me distinction. Because these people aren't gonna take that. These 12 people in Harris County doing the Allstate audit aren't gonna appreciate that answer. I need more. And I just stayed on them like that. Literally, it was like a whole block of questions.
I mean, like 7 out of 10 when you don't know what an actual 7 out of 10 is. It's different, right?
So here's what saved us, or here's what, I don't know if it saved us, but here's what was great. And so I thought my cross of my own client was effective because it allowed us to get way in front. We obviously we talked about pre-existing conditions,
right,
and not discounting people's problems and then walking through an opening. But then we could just address it and then talk about this. And then, the defense counsel still tried to get up and go through some of those things. And what about this? And what about this? But, oh yeah, I already told these people.
That must have been like the shortest cross for the defense counsel on that one.
It was great. It was great. And then, so the real benefit of it, and I didn't really understand, and it scared me when it happened, but we were able to bring his wife. So this is the guy that I was taking. His name's Brad. I ended up being able to take Brad's wife and by Zoom. And I had talked to her a little bit, but we're busy and there's not a whole lot of time on these $2,000 offer cases to figure out what exactly they're saying.
Yeah.
So she had been under the weather. She wasn't doing well. Turns out, I mean, this lady was just phenomenal, and she gave great testimony. She talked about what to do and the way that they've been different and the problems with the business that have been caused since this accident, which are all things that we got into with Brad, but so much more effective when it's coming from somebody else, always.
Yeah.
And also, mind you, that we talked about how with Brad's stuff, we never shied away from the fact that he was working and out there working what he had to do because we wanted to tell a victor story, not a moping story. But Andrea, his wife, she goes on there and she said, I didn't even know he had a problem with that. What? Yeah. Which that's exactly what I did. I was like, oh God. Like, is she going to come off here as being like completely uncredible? But she's like, yeah, I never really knew it was an issue. I didn't even know he was going to the chiropractor. He was going to the chiropractor.
Oh my God.
So,
do you know what your husband does?
Literally, I was like, oh God. But she was great. And then I'm sitting there going like, geez, what am I doing with this? This was going to be something. She's going to, either she's not credible or there's lack of communication of what does she really know or like, what is going on here. The way I looped it back when I did, so Nancy closed, phenomenal closing, and then I came in and did just a rebuttal, and I literally just like pulled my hair back. Hey, look, y'all heard Andrea talk about this, and she said she didn't even know that Brad had a problem or he was dealing with a chiropractor. And I didn't get it. I didn't understand. I really didn't understand, but I do now. Those chiropractor visits and his neck problems, they were never a big deal. It was never a thing. It's 7 out of 10 on the page, but that doesn't mean nothing.
Yeah.
Who's going to walk into a chiropractor and say, hey, look, I got 2 out of 10. Hey, doc, here's what's happening. Hey, my 2 out of 10. Soft. Get out of here. You work on pools all day, bud. Taking a leave or take an aspirin and like, go figure it out.
Yeah.
You know, but he's walking in there going, yeah, like my neck's bothering me a little bit. But it was never a thing. And so that's what I told him. I said, look, it was never a thing. It was never a thing. And that's what Andrea came here to say. And I was terrified by it, but I understand it now. Now I get it. Now you get it. It was never a thing. What was a thing? That accident and everything that followed.
Well, one thing I got to ask you guys, I'm always terrified to put a wife on the stand because there's obviously at least some sort of bias there. Were you guys scared about that at all?
Yeah, but who else are you going to get in some of these cases where you don't have a huge disclosure list and a whole bunch of witnesses to choose from and want to show up? I mean, you got what you got, and ultimately,
it worked out for you guys.
You have to put the product. You have to put stuff out there, like the pictures of the MRI,
right.
the pictures of the ESI, the pictures of the crash, the property damage. Witnesses who are not the client to give testimony. If you don't do that, you're never giving yourself a shot. Fundamentally, like you have to put on the best Netflix TV show or whatever you possibly can.
Yeah.
Using the rules of evidence, rules of procedure, make sure you do it all appropriately, don't get mistrial.
Yeah, that's what I'm worried about every single time you talk to me about something. I'm like, oh, no, it's not. But okay,
it's not. And so long as look, we never hide our cards. Like we never hid our cards. We put everything up front. We were very transparent, and then we didn't really have that much in the way of objections to anything that we were doing. I don't even know. I mean, like, look, it's just when you have these UM/UIM cases, they're just a different kind of animal. So long as you know what you're doing on that front. And the biggest shock was not being able to call the adjuster. I wanted to ask some questions. I was going to go into like SEC filings that all could have done and try to show that the CEO for Allstate had made $17 million. I was going to do all this stuff because the Allstate SEC filings talk about how the liabilities are, the potential money that they have to pay on claims, but they also acknowledge people that typically hurt in these acts. Like there's great stuff in those documents, which are the statements of Allstate, and which are complete public record that they put on with the SEC. So there's 3 separate documents, and I was going to try and introduce all those. And the judge was going to say this case is about the injuries, not about that. And I wanted to say, well even Allstate acknowledges that there is a time value quotient, or how long these people have to deal with their injuries, that is part of their potential liability. But it's how long these guys have been hurt. Yeah.
I mean, insurance companies are all about liquidity. They can pay a claim out 5 years from now instead of now. Way better for them.
Yeah, well, wouldn't it?
Yeah.
And so, but there's literally there's phrases that are good to that end, to establish that end, establish why they're like, 1, we know people are hurt, but 2, we would much rather not pay it out now because we'd rather invest in float and take that.
Like, so if I pay in Q4, I can do more in Q1, right?
Exactly, man. So I was going to try and put all that in.
And who's the judge?
157th on you. Yeah. She's a great judge.
Yeah, she's great.
She's so smart.
All right. Talk about this docket depot, because a surgical wreck, I hear different things. I won't say my opinion, but it goes either way. Some people are like, surgical wrecks mean nothing. And obviously you guys got that included. So how'd you do this with 6 years difference, no surgery in the middle of all that?
6 years of no treatment, following 20 years, a bunch of treatment.
Yeah.
I don't know, Nancy. How do we do that? Take it away.
Take that.
Look, I mean, fundamentally, the great thing about UM/UIM cases, man, we did a bunch of shit. So, the doctor depot, we had a really great senior lawyer, formerly AW, kind of stepped off and did a wonderful job with this doctor depot. And, he was able to, he did everything properly. He thought the foundation, it was good, it was concise, straight to both treatment, why do they need the surgery, how the surgery and how would it help them, and then how much does it cost? So all of that came in, all of that was great. What we did was, one was we said it was about hope, obviously. I mean, these stories are stories of triumph. Anytime that I have cases, I'm not telling stories about this is awful, blame the defendant, do any woes me. It's the victor's tale. It's the story of a winner, and it's a story about how the jurors can support that progress or that journey of helping these people better. So we say, look, this surgery can help them.
Yeah.
And that's confidence. I think, well, if they're going to have the surgery, why didn't they have it? And all this stuff. And he tried to get in the fact that they had insurance for other claims. Collateral source for them.
Yeah.
What do you
say about insurance? Did you talk about health insurance? Or?
Yeah, he wanted to be like, look, they could have paid for it. I know. I'm like, that's ridiculous.
Okay.
So, but that's what he tried to do. And so, because he said, look, they say these surgeries, they could have had them, they didn't have them, and all this stuff. So that when I got up there, I was like, and it's on closing. It's going to pay for it. I'm not going to pay for that. Yeah. You want me to pay for that? Not me. Are you going to pay for this? Who's going to pay for the chance for these guys to get better? Is it going to be you? Is it going to be me? We're going to foist this on a society? Or is it going to be the company that these people paid over the course of since the 1990s for exactly this type of scenario when they would need the help and the opportunity to get better? So the surgery said, look, we're going to help them get better. This will help them to get better. The docket depot was built in to do that. And it was great. And we could talk about what it was. And the slides are powerful. They show the doctor and they show the diagnoses and the fusion necessary and why, and it's going to be beneficial for quality of life.
Right.
And so we say exactly that. And we say, who's going to pay for this? Who's going to be responsible? Isn't it supposed to be the company that said it was going to give you and put you in good hands? When this unfortunate thing happens and you actually need a helping hand and need some help, who's going to pay? Who's going to help these guys get better? And that was the real thing on it. So they asked about, or somebody brought up past medical, even though we didn't submit it, which maybe I should have said that objected, but again, you don't want to bring attention to something necessarily.
Right. So
defense counsel gets up and goes, you haven't shown you a single bill. We just dropped all our meds. I dropped every bit of the medical. I did not go in there with any medical.
How much? Yeah,
it's like 40.
It was 40 combined, yeah.
It was like 40 and something else. Yeah, it was close.
Maybe like 20 each. We'll just say.
I don't want to say it was even more than that. Wasn't it? Was all it was?
I want to say it was less. It wasn't.
Well,
it wasn't anything
story, let's say it was more.
Yeah, I mean.
So anyway, we dropped.
Let me ask a different way. They went to the ER.
They did not.
They did not. Okay, physical therapy.
Yes.
Injection.
Yeah.
It was MRIs. Yeah.
Soft
couple of injections.
injury,
yeah.
Okay, so we're looking at anyone else looking at this as like 30, 40 K.
It's 40. It's like 40 more.
Okay.
And so
you're going to drop those.
I dropped all of it.
Okay.
No low numbers.
Okay. That is bold move.
No low numbers.
Bold.
It's not bold. It's smart. Like if you like blackjack, you like poker, drop all your small numbers. Drop all your small numbers on all your cases. Do not submit your past meds. That's hardline rule. Hardline rule. Best law firms in the world, best law firms in the United States, including Abraham Watkins. I don't know if everybody does it, but most, unless you have like a 7-figure past medical bill and a life care plan, it's like huge life care plan in the future, drop the past meds. Why? Why are you anchoring yourself to low numbers? The only hard blackboard numbers that we submitted were a $180,000 surgery and a $140,000 surgery.
We're putting big numbers in front of them. I mean, I believe the whole tactic is you're putting these numbers in front of the jury. You're saying, oh, they have $10,000, $20,000 in meds. Right. You're already putting a number on the case, right? The jurors are already thinking, okay, well, what is this case worth? Well, if they had 20,000 meds, that's where we're going to be. And
your first number is not a number that you guys are going to want, right? If you're asking for that much money and the first number they put down past medical is 40, it's going to be real rough to put bigger numbers on those other ones.
So defense counsel goes, well, where's this medical? Where's this medical and all this stuff? And so I get up and I'm like, I'll show you where it is. They're right here.
Rebuttal?
This is in rebuttal on my phone. So I'm like, I got exhibit 36 and exhibit like 45 right here. They are. They're the settlement releases from the underlying settlement, from the underlying tort fees. I put those into evidence. And I said, guess where that money went? Guess where those past meds? Guess who paid for that? That's an insurance company defendant taking responsibility and accountability for what they did. We know how insurance works in Texas. Ain't got to cover $180,000 surgery. Y'all know that. Who's going to pay for that?
So when you looked at defense counsel, was he just all red? Was he on fire? Was he just like, I need to call the adjuster?
Yeah. I just think they don't know. I just don't think they know what they're getting into with us sometimes. I just don't think there's an orthodoxy in the way that people practice these cases and what they do. And I think
it's a requirement. Right?
I think Nancy was saying recently, like, look, everybody's just running off the script, and we were just so off the script in every way. It was like, how do we?
So here's what I've noticed, and one of the reasons why I asked Kevin. You guys did stuff totally different, right? When we spoke and you told me about the case, I was like, what? Like how, right? And I've noticed there are two ways to look at a claim. On the insurance side, they have a script, all right? And I'm telling you right now, if you see a defense attorney go off script at any point in time, they're getting chewed out when they get back, okay? They have people in high rises in New York who are putting together what is exactly needed because they think that statistically speaking,
law of large numbers,
it will get things down in the grand scheme of things.
Yep.
And to be honest, it works for a lot of things. But if you take a case like y'all and make it in the most unorthodox way, which this is unorthodox, right?
Yeah, absolutely. Although I wouldn't say, look, I think there's so much out there in terms of the cognitive sciences, the way that jurors think and the way that people think and what we have now. It's unorthodox in the sense that we have, there's a way to try these cases that people do for so long that feels safe, and the insurance companies understand it too, and so you're all playing the same game.
Yeah.
Well, it's not a very good game. We know that the insurance company wins with the law of large numbers.
Yeah.
But, I mean, it's the most genius business in the world because they can go literally quantify every risk, figure it out, and extrapolate out and go, here's where it's going to be. Well, I don't want to play on that. I don't want to do those things. So part of it was out of necessity in this case that we had to be asymmetrical, meaning do things differently. But it's also because we know and we studied and read and look at the studies and say, can't ask for too much. Don't submit low numbers. And then Nancy and I were just talking about this at lunch. Being a great trial lawyer means being present, and it means being fluid because this is live action. Just like professional sports, this is the only other occupation where you have a true adversary that's literally across the aisle that is competing in the telling of a compelling narrative. And they're there to frustrate your process, and you're there to sort of basically, frankly, in my opinion, they're irrelevant because whatever they give me, I'm going to make it as good as possible and spin it how I'm going to spin it. But that's our job. So if you are script driven, I don't know how you can say you're a great trial lawyer. That doesn't mean you don't have great preparation. Doesn't mean you don't think your team's through. It doesn't mean you don't have a narrative, which we did.
Right. But
we allowed ourselves the agility and the latitude to be present in the moment. Andrea, with the thing, I had no idea. I didn't know how to respond to it.
Right.
But I knew how, in my mind, I'm like, it's not a bad fact. It's a good fact. Bad law, worse facts. Screw it, man. They're all good facts. Like, just take them and work them.
Yeah, I'm using that snippet, by the way, just a heads up. Or the tech issue you guys had, right? That's not always helpful as well, too. It's a good point. You're exactly right. And I kind of look at it like the defense's job is to break down the house that we're trying to build. We want the jury to come in, enjoy everything in our house, right? And so if we build, people in the Heights area know just cookie cutter townhomes, yeah, we'll probably get some settlements. But do something like what you guys did. This is something you've got to man-make, right?
And what are you doing this for? Your clients have one opportunity. This is probably, hopefully, God willing, it's the only trial they're going to have. Civic trial they're going to have one.
Right.
And for us as young lawyers, how many opportunities do we have to try cases and exercise these skills and be advocates that we do? Yeah. Shame on you if you don't take the opportunity, coward. Shame on you. Take your shot. Take your shot. Don't be afraid. You're not going to fail your clients. You won't. You'll do great. Yeah. Take your opportunity. Try something. You'll do great. You'll do great.
And you won't get the what ifs if you lose. Right?
And you won't doubt yourself. I mean, I have the benefit of living a life where I've played sports at a really high level. I was a college football player, national champion. And I was trying to play pro hockey for a minute. So I've done all these things, and the only regret that I've ever had in my life is not being elected. Which is, you know me, Mike, a little bit, but
that's saying a lot.
There's no time for timidity, which is not to say you don't have tact. You always have tact, and oftentimes discretion is the better part of valor. But take your shot. Don't be afraid.
Yeah.
Don't be afraid. Why? I mean, go ask. Go ask, and have a justification for your number, but go ask and try tactics outside of the box.
So who did closing?
I did closing. Yeah.
You guys tell me about that. So you're the ones who coming in. You're the ones coming in and saying this is the big number.
Billion.
Right. Yeah. So I'm the one kind of laying it out for the jury. We put it up. We put the jury charge on a projector, and as I'm saying numbers, Teddy's writing them in. Right. Yeah. So we're giving them a visual of that. Closing, I don't want to say it was hard at all because our facts, they were a little tricky, sure.
Yeah.
But, our clients were great. All our witnesses were great. They have injuries, they're injured. We have a Dr. Depo kind of proving up the surgical wreck. So it's just putting all that together. And then also, you're also looking at what the defense attorney is saying, right? What are they hanging their head on?
So what was it?
For them, it was just their past injuries. They were saying, hey, they've been injured in the past. They've been injured after. They're still playing basketball. They're still playing racquetball. They're
what have they done
not injured.
What have they done in 6 years? Nothing.
What have they done in 6 years? Right. They haven't gotten medical treatment. They haven't gotten that surgical recommendation, that surgery within those 6 years. So why are they here now asking for it? Right. Yeah. So why are they here now asking for it? Well, they haven't been able to get it because you haven't, paid for it. The insurance company hasn't, paid their premiums.
Good answer. The second you pay for it, we got it. Thank you.
That's what we're here for.
Help us out.
Right. Yeah. So it's just putting all that together, making a good story for the jury.
I was able to do the rebuttal, the final bit. But right. I hate these defense scripts when they try to do stuff like increase the burden. Like they'll go like, it's supposed to show you the cards and all that shit.
Yeah. So is he just pounding? They didn't meet their burden.
He did some of that, honestly, but mostly that's part of his script. Against who I adore. He's actually a real sweet guy.
Oh, he's awesome. Apparently very charming in trial. We're not going to tell who it is, but yeah.
Right. And he was very competent, did a good job.
Yeah.
Just had, I don't know, like some kind of like switchblade drone system that nobody was used to. They're like, we've never seen this before. we were doing weird stuff, I guess. And but yeah, no, he was like, they didn't show you cards. I don't have to show you. How about them? They haven't shown you anything. They haven't done anything. Let's flip the script a little bit here. They want to poke. They want to try and say our evidence is deficient. Well, where? It's what? We talked to you about it. We've shown you what this is. And what I wanted to do, and I'm kind of mad at myself, but I wanted to he did the thing. I think I said it. Where you have to show your cards. I wanted to be like, in my head later on, I wanted to start throwing out papers and be like, Andrea Key testimony, that's an ace. Dr. So-and-so, that's an ace. Something, that's an ace. And guess what? By the way, I don't need full house like I got. I only need a pair of twos. Something like that. I didn't do it.
I'm pretty sure Judge Garrison would be like, can you get those cards off my floor? Thank you.
So Judge Garrison, I was going to do this whole thing, and she shut it down. I was going to do I was going to quote the Lades of Ancient Rome and talk about how these people had an opportunity to stand up and diet and this whole thing and face overwhelming odds. And do this whole thing, and she was like, she was like, we're here to talk about damage. I'm like, you might be.
She's like, you're about to get kicked out of this courtroom, so please just stop.
You might be. No, but it was good, and we dealt with it. Well, it's funny. We got juror comments back later on, and look, I need to refine my own performance as well. And if I have an issue with that, look, I do that. Chance McMillan is really great at these cases. He has a lot of passion, like I do. He's a lawyer here in Houston, Texas.
He got a verdict 2 weeks ago.
Yeah,
in Garrison's court as well too.
Really good verdict. Yeah.
UIM case.
That's right.
Yeah.
Right.
Yeah,
and so
did a great job.
So we had talked about how passion was one of our big things, and he said that he brings it up in the fire about how you're not going to hurt my clients or take it against my clients. He's passionate. Garrison, after the fact, Judge Garrison said, "Hey, you are way up there. Like you just have so much confidence and so much. Like you need to just find a way to refine some of that and bring it down a little bit."
Yeah.
Sure enough, we get juror comments back. Judge Garrison submits these papers to jurors. Yeah, everything was really great, and the trial was really good and all that stuff. It got real scary when Mr. Festeryga started yelling.
We call that passion.
Because I was screaming, I'm like, if my sister who just got hurt in a skiing accident had to wait 6 years because she had a fractured wrist, if you're telling me that, I'm pissed. All this stuff. I don't know exactly what I said, but I'm kind of an in the moment guy with separation. But yeah, it was definitely genuine and authentic, and we gave a full and compelling rendition of what we thought was surgeon.
How long did they deliberate for?
A long time.
Judge Garrison. Well, I will say this: Judge Garrison handed the verdict back to these people at what 5 o'clock on.
It was about 5 on Tuesday.
Did we start on a Monday or did we start on a Tuesday or Wednesday? But anyway, it was the second day of trial, and she gave it to them. So they could have gone in there and like, nope. We just gave them a little bit and got out of there.
Yeah. And
that was my concern. It's like, oh God. I mean, you're giving, because then, it's their liberations, they got to come back and say.
Yep.
But these people cared. They were engaged. They thought about it. And so they went in there, took it home, slept on it, came back the next day, and it was maybe 3 or 4 o'clock the next day. So it was, I mean, they spent some real time. Apparently, they said they reviewed the records. We talked to a couple of the jurors afterward, and they were like, yeah, we really wanted to give these guys more, except, you know, they were playing racquetball and they were doing all these other stuff and the things. I was like, yeah, it's probably fair. Probably fair. You know, they'd be playing a lot better racquetball if, you know, you'd been helping out earlier.
Better score, I guess.
Yeah. He didn't say in there when he's winning or not. He's probably losing that game. So there's a whole thing. That was great.
Man, this has been informative. Like really, like I really mean it. Like these cases they're different, and I feel like at least for a young attorney, you know, these are one of the first cases you should try, because you could try do anything there, and may not be successful, but you may, you know, almost $500,000 verdict, right? Yeah. I don't think that there's any limitation.
Yeah, no, and you know, going back to what we were saying a while ago, it's just like it's getting out there and trying a case, right? Like for me, I mean, it's my second case. I haven't tried many cases. As a matter of fact, I haven't even seen many cases. My first case was within a year of being a licensed attorney, and I had never seen a case. And they're like, "You're going to go first chair." And you know, a lot of attorneys that I've talked to, they're like, "Well, you know, how do you do that? Like, aren't you scared?" I'm like, yeah, you're scared, but also this is why I'm doing what I do, right? Yeah. And also, you don't learn from your mistakes unless you're out there and you're trying your case, right? Bernard Shaw, I believe, American journalist, he said, you know, if you teach a man something, he doesn't learn anything, right? Because you've got to get out there and try it. It's an active process. So yeah, I mean, after that trial, I went back home and I said, okay, what can I fix? What can I do different? What worked? What didn't work? Yeah. And you don't get that unless you're trying cases.
Yeah. Absolutely.
I would say, the benefit of you having your own cases is that inevitably you get a great defendant. Oh yeah, you got a great defendant. So that's the number one thing. You got your villain. So they're really easy stories usually. Even if, look, you're going to have you might have to dispute the liability, but typically the actual court fees are not going to be. So even for people trying those cases, who's going to subpoena that person to show up? And then what you can say is, look, they're trying to point the finger at the underlying thing, and you have to prove up your liability case, but it's a little bit like proving up a motion for default, because they're not going to have anybody there.
Right.
I'm sure there's a lawyer talking about some stuff, but it's not so hard.
It's not very good.
And everybody knows that it's just the insurance company at the end of the day who's still involved. Yeah. So they're real clean stories. If we're talking about, you know, Joseph Campbell and the hero's story and the narrative arc, they're easier stories to tell. And I think, honestly, it becomes a lot more fun the more complicated, the more issues that you have to face, because it gives you stuff that you do have to resolve and real conflict. Yeah. How do you tell that? It's engaging, and that's fun. And I would say, look, don't be afraid. Try all kinds of crap. Let's see what happens. And guess what? So long as there's no objections and no trial motions, which if you're a young lawyer, they're not going to give you a bunch of. You're going to get a lot of leeway to try a bunch of stuff. Yeah. You're just going to get it. And older defense counsel aren't going to want to beat up on you too much. And guess what? If they do, take your licks and learn from it. Try. I do all kinds of those things. I pull up YouTube videos and depositions. I go to depositions with an iPad. I put up a YouTube video and I'll say, "That's essentially similar to your accident. Did this happen the same way? Were you in the same position?" And defense counsel's like, blowing up. I'm like, "Look, I'll attach the depo as an exhibit. Relax, man. We're just going to use it for demonstrative purposes, but I do want to see that the fall protection snapped and my guy fell 3 stories." So I think people need to see and understand. Yeah. And 30-year lawyers have no idea how to respond, and so long as it's substantially similar and assisting to the jury and helping the jury in their analysis of the case, well, guess what? Yeah. The judge can still say no, but then the defense counsel has to deal with that risk of that coming in and think about that when they're writing their reports.
That's always a problem, right? And that's always, again, it goes back to what we were saying. What I like that you guys did, or it seems like you guys continue to try to do, is you're not thinking about what on the checklist in the report is going to do it. You guys are thinking about what at trial can I do to beat a director, right? Exactly. And by doing so, they're going to have to write something in the report about this. They can't just, for example, with the demonstrative evidence of the YouTube video, they can't just be like, "I'm going to skip it." Right? Yeah, exactly. They have to be like, "Hey, by the way,
here's the link,"
or individual.
Y'all should watch this.
They have this video. It's kind of shitty for us. attached exhibit,
Yeah.
right?
Yep.
And
They figure out what your foundation is for demonstrative, take a look at what the law is for demonstratives, and then go try to use those. Now, we don't, for any real trials, AW does not go and we do not try in substantial cases without medical illustrations, medical demonstratives, liability animations, or liability demonstratives, because you need to put on a compelling performance. That's just, we know that that's what it is.
Testimony isn't enough nowadays. It's just not.
It's not.
And I don't think it ever was, but now I think it's way, way worse.
And you have to pray for somebody that can do a good job, and you need to figure out how to get yourself out of the way. And it's just too complicated. That's also why video depositions are so useful, because especially if you're on Zoom, you have total and complete control over the way that you present an exhibit during the course of the deposition, and go picture in picture so long as it's all admissible.
Right.
There's no issue. There's no issue. And so you can play it, you can cut it, play it, show it, do whatever you want. Don't limit yourself. I think one thing that people make a mistake of all the time too is not creating exhibits for their depositions. But once you get a little bit of confidence going, like I'll full on make an exhibit. I'll stop and I won't even stop. I'll keep on the record, and I'll pull up a Word document, put it on the table, and start typing stuff out. So what? You're gonna cut it different. I don't say ever. Usually, I'm pretty clean in my prose, but
There it is.
I'm pretty clean about that. That's for fun. That was for you guys. But you're gonna cut all that stuff out.
Yeah,
you're gonna cut all that stuff out when you go to clean it up, and it's not gonna come through in the transcript. And doing that and speaking slowly and figuring out how you want to do it, and knowing that you have complete latitude to kind of cut your depositions the way you want, it gives you the freedom to try things. And so long as you know what you need to get, you know your foundation, know your charge. If you don't know your charge, you're walking out there blind. Know your charge, know your law, know the absolute baseline stuff that you need to, then go out there and figure out how are you to tell the compelling truth that is your client's story.
Sure. Well, guys, I appreciate you coming on. Probably going to have you guys come back when you get a bigger verdict.
Absolutely.
Which seems like it's going to be pretty soon.
July 18th, I hope. Well, July 18th, I hope we go to trial. We got a big case in Judge Garrison's court again. So stay tuned.
All right. Don't get kicked out. I'm very worried about you getting kicked out.
I will not. I will definitely. You'll hear about me. There definitely will be a contempt. I'll have a contempt moment. It'll probably be in federal court when I'm in federal court.
They should just have like an AW cage and just kind of like put you in there, and they're like, all right, trial starts. Well, thank you guys so much for your time. If you guys want to get in touch with anyone at AW, we're going to put their emails. I'm also going to attach a link to the PowerPoint. It's really helpful for our viewers who are watching, listening to this, not seeing the video. Super helpful. Anything else you guys want to talk about?
Oh man, thank you for your time. You're doing a great thing, and all of us are learning. So I know I listen to your podcast, great podcast, and we got great lawyers on. Happy to be in those ranks. We are not up and coming. We are seasoned lawyers. We are here now. We are here to go to work and help people today. So
the new generation, right?
Right.
Yeah.
Thanks for having us, Mike.
Absolutely.